Good afternoon, everybody. Welcome to this IP webinar, which we're hosting here at the NIHR Academy. I'm joined by two of my colleagues from the NIHR IP unit, who I'll introduce themselves in a second. So I'm Pete Thompson. I'm Director of Programs and Impact here at the NIHR Academy. And for the next half an hour or so, we'll be talking through a few slides around the considerations you need to be thinking about when it comes to intellectual property, and also to finish off a couple of slides talking about the opportunities we have for collaborating with industry and how you might want to think about using those. And then there's going to be plenty of time for your questions at the end. So I will say, as we're talking through these slides, if you think of questions, please do submit them, and we'll get round to answering as many as we can when we get to the end of the webinar. But I will let my colleagues introduce themselves, who are going to take you through the first few sets of slides.
Sure. So, hello, my name's Lee Allen. So I'm Assistant Director for IP and Commercial at NIHR.
My name is Charlie Morgan, and I'm also a member of the NIHR IP team. We will cover four main topics in this presentation. Firstly, we will discuss the NIHR's perspective on industrial collaborations and why we see them as something that has the potential to create significant benefits for health and care research in the UK if relationships are managed appropriately. We know that IP is a topic that many researchers feel uncomfortable about. So we will give you a summary of how NIHR views intellectual property and why we think it is important for health research to produce impact. Industrial collaborations have a range of issues that need to be considered and are beyond those normally encountered during academic research. Our third topic is to highlight some of those issues and explain some ways for researchers to manage them. And finally, we will focus on funding opportunities available from the NIHR Academy that will promote industrial collaborations. Moving on to our first section, we will now discuss industrial collaborations in NIHR funded projects. Some researchers have concerns about working with industry as they feel it may affect their academic integrity or independence of their work. As a funder, NIHR obviously wants researchers to maintain their academic integrity and independence, but we don't see them as mutually exclusive to working with industrial partners. The challenge is to develop collaborations between academics, clinicians, researchers, and professionals in industry that are mutually beneficial. This requires clear communication between all partners and ultimately legally binding agreements to ensure that all parties understand their rights and obligations to the others. NIHR is very supportive of industrial involvement in health research if there are clear roles for each partner and clear lines over what is and isn't permitted. Companies ranging from small spin-outs to large multinationals can contribute people, knowledge, expertise, and resources to research funded by NIHR. And often the contribution from industry is something that only a particular company can provide. Therefore, without their involvement, research couldn't go ahead. For example, a company may have developed a new medical device, drug, or intervention that has the potential to significantly improve healthcare offered to patients, but it may need research to produce evidence needed to convince health and care service managers and regulators that a product or service would be beneficial for patients. If collaborations are managed correctly, the NIHR funded research can lead to adoption of new technologies by the health and care system. Clearly, there is an opportunity for companies to profit from the adoption of their technology. So the NIHR contract has a number of checks and balances to ensure that the taxpayer contribution to any research funding is recognized and valued by industrial partners. The NIHR research contract is designed to protect taxpayers' interests while recognizing that other stakeholders, including researchers, patients, and companies, all have legitimate interests in the research outcomes. Therefore, a legally robust agreement must be reached by all parties before research starts, so that all stakeholder interests are respected. Intellectual property may seem like an obscure and uninteresting topic when you're planning health research, but it's actually a critical component to ensuring that collaborations with industry go ahead without any unexpected problems. The intellectual property laws in the UK and most of the rest of the world are designed to be a legal framework that protects great ideas and ensure that whoever has that great idea can make sure it is used in an appropriate way. Because NIHR funded research will result in new knowledge being created, we want to make sure that all parties involved in the research understand exactly what rights they will have and also what they will not be able to do. Intellectual property is a legal toolbox of strategies to capture and manage research in the most appropriate way for a particular project. A critical point about NIHR is that all of the money that we provide for research comes from UK taxpayers. Therefore, we have an absolute responsibility to ensure that taxpayer funding is used in a way that is in the taxpayers and wider public interest. Defining the ownership and rights to use intellectual property is therefore a very important part of our strategy for ensuring that all aspects of research are in the public interest. Clearly, companies are normally driven by a goal of maximizing profits for their owners. This is a legitimate organizational goal, but it's not NIHR's role to directly or indirectly support companies in improving their profitability. Therefore, we need to carefully balance the public interest outcome of better health research with the commercial dimensions of a company's activities. To do this, we have a commercial use consent clause in the NIHR research contract that enables us to manage these competing priorities and, if needed, could mean that the NIHR refuses to allow research that it has been funded being used for commercial purposes if that is not in the public interest. We don't want to do that, so that is why we place such emphasis on early understanding of proposed industrial collaborations. So we have said that intellectual property is important, but that raises the question, what is IP? The World Intellectual Property Organization defines IP as a creation of the mind. It is important to note that ownership of a physical object and the IP rights to that object can be different things. For example, when you buy a book, you own that copy, the physical object, but you do not own the intellectual property, the copyright to the text. So you cannot make additional copies. So will your research produce IP? And the short answer is yes. But let's look at this in slightly more detail. The NIHR funds a very broad range of research, and as such, the IP arising from that research is varied. It is very likely that NIHR funded research will produce things like new local guidelines and improved checklists and questionnaires. Almost all research funded by NIHR will result in new know-how, for example, in the form of new methodologies, new clinical trial management techniques, and new data analysis methods. Database rights are another form of IP that will normally be produced from NIHR funded research. Please be aware that data is often forgotten when considering IP, but in many cases, it is a valuable outcome from NIHR funding, and it should be disseminated and exploited appropriately, made available for research purposes where possible, and definitely not automatically given away for free to commercial organizations. NIHR funded research often produces IP outputs, such as national guidelines, toolkits for patient care, and software tools, for example, mobile phone apps. New or improved medical devices and pharmaceutical drugs can arise from NIHR funding, particularly in funding from the Invention for Innovation and Efficacy and Mechanism Evaluation programs, but this is much less likely to occur. Therefore, the takeaway message is that the vast majority of NIHR funding will not produce patents or commercial outputs. However, NIHR funded research is likely to result in IP that can achieve patient benefit if appropriately exploited and disseminated. Having said that, where there are potentially commercial outputs arising from NIHR funding, it is important that they are carefully managed from an early stage to ensure that patient benefit can be maximized. So why is IP important to the Department of Health and Social Care, and therefore to you as researchers? I'm sure you will all agree that research of all kinds generates value and has the potential to positively influence service and treatment in the NHS. However, as we discussed on the previous slide, research also creates intellectual property. IP can just be thought of another type of result that needs to be disseminated, communicated, and exploited appropriately to achieve patient benefit. Protecting and working with intellectual property does not need to impede publication, which is sometimes a concern for academic researchers. The Department of Health and Social Care recognizes the importance of intellectual property as a legitimate output of research. With this in mind, IP arising from NIHR-funded research should be managed in parallel with publications to deliver maximum benefit to patients and the NHS. Whilst publication in academic journals and presenting research at conferences are both important, traditional academic dissemination routes are quite passive and rely entirely on the information being sought out by the relevant people, either by reading the paper or attending the conference. For this reason, the NIHR actively encourages research teams to develop and implement robust knowledge mobilization plans to ensure benefits to patients and the public can be captured and measured. How can you make sure information is seen by the people that need to use it? Where IP outputs are tangible, for example, devices or software packages, the most effective exploitation route is often clear. However, IP outputs such as guidelines, database rights, and know-how can still be hugely valuable in terms of patient benefit and should be disseminated and exploited effectively. There are a number of mechanisms for disseminating this less tangible IP, including academic publications, press releases, the NIHR Applied Research Collaboratives, the academic health science networks, social media, and patient interest groups. The NIHR funds an extremely diverse range of programs, personal awards, and infrastructure. This diversity is due to the wide-ranging needs of the health and care system, the wider public, and individual patients. The diversity of funding streams also means that we have a broad definition of what patient benefit is. This allows researchers to produce patient benefit in whatever is the most appropriate way for their research. This slide is a non-exhaustive list of the ways that patient benefit can be defined. We want researchers to explain how they will use their IP to produce one or a combination of these types of patient benefit, or something else that is not on the list. You are the experts in your field, and so we as a funder are happy to support any type of patient benefit that has an appropriate justification. Researchers tend to associate IP with profit, but the NIHR strongly believes that patient benefit does not need to be an economic quantifiable outcome. Instead, it is entirely valid for patient benefit to be a qualitative improvement in how patients feel or how they experience their interaction with the NHS or care systems. These qualitative benefits are often equally important as financial benefits. So IP is a tool that can be used to produce qualitative benefits just as much as it can be used to produce profit. In cases where there is commercial use of NIHR-funded IP, or you wish to license it to a third party, then the NIHR contract requires you to obtain consent before this occurs. This ensures that we have an appropriate oversight of how IP funded by UK taxpayers is used. In some cases, we will require a revenue share agreement or other return to be agreed as part of the consent procedure. We will negotiate this with you on a case-by-case basis, taking your unique circumstances into account. We do not look for an unfair slice of any revenues produced, but we do expect that a return recognises the UK taxpayer contribution. We've discussed intellectual property as a general term, but it is possible to define some particular types of IP. This is an important step to agreeing what different parties contribute to a project and what each party should expect to gain from a research collaboration. This applies to all types of research, including the projects where no patents are involved. IP is just as relevant to these projects. Two key concepts that we will discuss on the next slides are background and foreground IP. These need to be defined before an NIHR research contract and associated collaboration agreements can be signed. Although it may seem like an academic point, a clear description of both types of IP is needed in any NIHR application. This is so that funding bodies are confident that researchers will not encounter any issues that could have been avoided when trying to apply their research in a real-world situation. We appreciate that issues will be uncovered during the project's lifetime, but we need to be satisfied at the time of application that an appropriate level of review on the IP position has been completed. This review is sometimes called due diligence. The extent of due diligence required will depend on the type of IP being produced and the route to patient benefit. Therefore, you need to review all aspects of IP management for your specific application. Background IP is a wide-ranging term that covers several different ways of creating IP. From the NIHR's perspective, background IP is any relevant IP that has not been produced using NIHR funding. This includes pre-existing IP owned by the applicants at the time of the application, IP produced during the research period that is not funded by the NIHR, and IP owned by third parties not involved in the NIHR funded project. Irrespective of the type of background IP involved, the NIHR needs a clear statement of ownership and contractual arrangements for its use if background IP is needed for the research or for producing long-term patient benefit. If another organization holds IP in your research area, your application may need to explain whether this will block your intended way of using IP and how you will address any problems. This is because we do not want to allocate funding when background IP issues would prevent short-term or long-term success. A strong application will explain how the research team plans to access background IP owned by a third party if it is needed for generating patient benefit. Your technology transfer or contracts office will be able to advise you on the best way to do this. And if there are any background IP issues, these will need to be detailed in the research contract under Schedule C. Foreground IP is a more straightforward concept. Our definition is that it is any IP that will be produced during the NIHR funding you are applying for. A strong NIHR funding application needs to adequately describe the types of foreground IP that it expects to produce and the arrangements for ownership and management. Our starting position is that any foreground IP will be owned by the organization that we sign a contract to perform the research. If you wish to propose an alternative arrangement due to pre-existing arrangements or a desire to simplify the route to patient benefit, please provide a justification in the application. For example, it may be entirely appropriate for any improvement to a software application to be owned by that party who owns the original software. We should mention that the NIHR generally does not accept joint ownership of foreground IP that it funds. Although joint ownership is easy to agree on in principle at the start of research, in our experience, it often leads to disagreements and confusion later on in the research period. Therefore, we rarely agree to joint ownership of foreground IP. In general, the foreground IP ownership arrangements should be as simple as possible and will need to be defined in the NIHR research contract. The arrangements for managing IP between any partners in a research project will need to be formalized in a collaboration agreement. The NIHR will usually ask to see a copy of the collaboration agreement before it is signed to ensure that it is in line with the terms of our funding contract. It is essential that all agreements are designed to ensure projects and IP are managed in an effective way. And please consult your technology transfer or contracts office to identify an appropriate foreground IP management strategy for your project and any contractual arrangements that will be needed.
So why does NIHR insist on a clear understanding of foreground and background IP ownership and management arrangements before providing funding? It's because we want to ensure that appropriate rights are in place to allow different types of IP to be combined to produce patient benefit. As shown in the diagram, background IP, foreground IP funded by NIHR, and IP that may be produced in the future using NIHR funded IP as a starting point, may all need to be combined to generate a tool, method, idea, device, or treatment that will produce patient benefit. The different types of IP produced during the whole research pathway can only be combined if appropriate contractual arrangements and expertise are in place. This is why we ask you in your application to explain the IP ownership arrangements. We will also review whether the team has an appropriate level of IP management expertise and experience. This slide assumes that you are considering your first application to NIHR. If you're applying for follow-on funding from an earlier NIHR award, then the foreground IP generated by the previous award will constitute background IP for a future application. So it's important to note that the terms background and foreground are relative to your current situation. So care needs to be taken to ensure that you understand how your IP portfolio will evolve over time. Patient benefit is our overriding goal, but different types of patient benefit will require different ways of combining IP. Your application must convince funding committees that you understand all the different types of background and foreground IP that will be involved. We also recognise it is likely that you will produce additional IP in the future that may be produced using other funding streams. Explaining how the NIHR funded IP contributes to the overall IP portfolio for your research is very important. Funding committees want to understand how NIHR funding will be a significant step forward in your pathway to patient benefit. In any type of research, it's important to have the contractual aspects under control. This is even more important when commercial organisations are involved. The diagram on this slide will attempt to summarise different types of contract that could be involved in an NIHR funded project. It may look like a rather complicated diagram, but your contracts office or technology transfer team are there to help you navigate this network of contracts. So please speak to them at the earliest opportunity. From NIHR's perspective, all work starts with the NIHR research contract that is used for all projects and individual awards that we provide. These terms reflect NIHR's requirements for how funding is used and also record what NIHR has agreed in terms of IP ownership, amount of funding, and reporting arrangements. Once the NIHR research contract is signed, other agreements may need to be put in place, and they may need to be compatible with the NIHR contractual terms. A critical document for industry collaborations will be a collaboration agreement that sets out the terms of how different organisations will work together. This means that right at the start of discussions about working together, industrial partners need to be aware of the NIHR contract so they don't have expectations about what the collaboration agreement will give them if they contradict NIHR's terms. Working with your contract or technology transfer office on this document is critical for the success of your research. NIHR will expect to see the collaboration agreement before it is signed to ensure that it does not conflict with our contractual terms. If appropriate, NIHR may require changes to the collaboration agreement before it is approved. If you are using more than one funder for your work, you'll need to review other funders' terms to ensure that all parties' rights and terms can be complied with. It is your organisation's responsibility to manage these different obligations to different funders. Depending on your project, you may need to put in place supply agreements or subcontracts. Again, these terms need to be aligned with NIHR terms. For example, if a company offers to supply a drug or placebo for free, then they should not expect to have preferential rights over NIHR's contractual terms. This requires early discussion of what industrial partners may want from a collaboration to see whether it's possible to deliver them from a project funded by NIHR. NIHR will ask to see supply agreements and subcontracting agreements to make sure they do not affect NIHR's contractual rights. If a project is successful and the best route to generating patient benefit is via a commercial partner, then legal agreements such as licenses will need to be negotiated. NIHR has a consent right to make sure that the proposed commercial use is in the public interest, and that NIHR receives an appropriate share of any revenue that results from the commercialisation of research that it has funded. So the NIHR research contract has been mentioned several times in this talk, and it's important for researchers to understand what it is. Fundamentally, is an agreement between the Secretary of State for Health and Social Care and the lead organisation managing the research. For most NIHR Academy Awards, the lead organisation will be a university or NHS trust. The contract details obligations that the lead organisation agrees to deliver in return for receiving funding, and also the proposed ownership arrangements for IP. For any commercial use, including with companies that have collaborated on the research, NIHR needs to give its permission via the consent right in the NIHR contract. Industrial partners need to be aware that NIHR has these rights, as we will exercise them to ensure patient-derived funding is used appropriately. We now move on to discussing what researchers need to have in mind when thinking about collaborating with industrial partners. If you're applying to NIHR, we know there are lots of things that need to be considered. The key piece of advice that we can give you is to read the program-specific guidance and the standard NIHR research contract terms. As an applicant, you need to be aware of the importance of IP. As we have explained during this presentation, clear access to background IP is vital so that it can be used to produce patient benefit if required. If an industrial partner owns some of the background IP, this needs to be clear in the application. Your research will produce some form of foreground IP that needs to be managed appropriately. Strong applications will discuss this in a way that is appropriate to the research that funds are being requested for. IP does not just mean patents. IP covers a wide range of outputs that need to be considered. Most research we fund will produce more than one type of foreground IP. So please ensure that you can demonstrate to our funding panels that you understand the full range of IP that you will produce. Where necessary, appropriate collaboration agreements should be entered into. Experts in your organisation will be there to help you. Patient benefit realisation plans need to be robust and reasonable. Different projects will have different higher risk routes to patient benefit. Please justify your proposed approach, taking any risks into account. And remember that achieving patient benefit isn't just about commercialisation. NIHR has a very broad definition of patient benefit that reflects the diverse types of funding it provides. Just because you do not have a commercial outcome does not mean that you can ignore IP. When dealing with potential or current collaborators, even in an informal setting, you need to be aware that what you say and do could have implications for how IP is managed during a research project. So if you believe that you may have disclosed any potentially valuable ideas during discussions with a company, it is important that you ensure a non-disclosure or confidentiality agreement is in place first. Your contract or legal office can help set this up. You should also involve your contract or technology transfer office in discussions with potential industrial partners so they can help make the process more effective and less stressful for all people involved. It is essential that you as a researcher know that you should not make any commitments about ownership or use of any NIHR funded IP to potential collaborators, however persuasive an industrial contact may be. Firstly, you are not able to make binding commitments as NIHR will agree management of IP with your employer. Secondly, commercial organisations may not understand NIHR's contractual terms, and these need to be explained to them by your contracts team. Thirdly, ownership of IP is an important point of negotiation, so making any premature statements can have a serious effect on those negotiations. Negotiations are never an easy activity, so please do not underestimate how long they will take, and include sufficient time in your project plan for negotiations to be concluded without delaying the research plan. The roles and expectations of any industrial partner must be very clear in any application to NIHR. We will ask you about any points that are unclear, so please work with your support teams to be able to provide a clear description of the proposed involvement of an industrial partner in your research plan. After listening to this presentation, you may be slightly overwhelmed by the level of IP expertise expected by NIHR. But this does not mean you as a lead applicant need to be an IP expert. In fact, we strongly advise you to seek the help of experts within your organisation who can help you provide a convincing justification of your IP management strategy in your research. A surprising number of researchers still tell NIHR they will be producing no IP with our funding. We hope this presentation has convinced you otherwise. However, if you genuinely believe you will not be producing IP, please provide a justification. A reason for no IP being produced is more reassuring to selection boards than IP being dismissed as not applicable. The experts who can support you will differ depending on your organisation. It may be a technology transfer office in a university, it may be a contracts office in an NHS trust, or it may be a business development manager in a commercial organisation. Please find the best source of advice available to you. External advice should not be limited to IP matters, and organisations such as the Research Design Service and Academic Health Science Network can help you understand the wider aspects of your research, including paths to impact. They will also help you submit a stronger application to NIHR. If you have questions about IP relating to a specific funding opportunity being advertised, please in the first instance contact the NIHR team that manages our funding stream. They will be able to provide specific guidance. The best route of contact is to use the NIHR website, which is nihr.ac.uk, where contact details are provided for all funding streams. We're now arriving at the end of the IP section of our presentation. Contrary to what maybe some of your colleagues may tell you, intellectual property isn't just about patents. Most but not all NIHR funded research will produce some forms of IP. This may take the form of rights databases, copyright, know-how, or formal patent claims, but it will depend on exactly what you intend to do. Researchers and their institutions need to manage IP correctly to achieve long-term patient benefit. NIHR recognises patient benefit can be a mixture of quantitative and qualitative outcomes. This means we need you to present a convincing justification of why your intended route to patient benefit is appropriate and achievable. Your application should explain as much as possible how you will recognise, capture, manage and exploit foreground IP to maximise patient benefit. The level of detail required will depend on your proposed research, its expected IP outputs, and how you will translate the research outcomes into patient benefit. Also, don't forget the importance of background IP. Industrial partners can bring fantastic experience, knowledge and materials to research funded by NIHR, which can allow important new advances in healthcare to be identified and evaluated. However, care needs to be taken to ensure that the interests of all parties, that is a research institution, patients in the study, NIHR as a funder and the company, are treated in an equal way. Therefore, if researchers are considering working with industry, they need to get the appropriate support as soon as possible to avoid unexpected issues that may delay research starting. Universities and NHS organisations have teams who are there to help researchers. Please speak to them for advice.
Brilliant. Okay, so thank you both. I think before we finish the sort of formal part of the presentation, I just wanted to highlight a couple of opportunities specifically through the NIHR Academy for collaborating with industry or for getting sort of additional training and skills around working with a commercial partner. So, as said right at the beginning, NIHR is keen to encourage working with industry and getting that right, and hopefully what you've heard today will help you understand some of the things you need to be considering when it comes to intellectual property. And certainly through the NIHR Academy, we are also wanting to encourage people, our members, and also people applying for funding from us, to think about opportunities about how you might be able to collaborate with industry to complement the work that you're looking to do through a fellowship or other training award. So just to highlight a couple of the areas that we currently have available through the Academy's various suite of awards. If you're thinking of applying for an NIHR fellowship, for example, if you are applying in partnership with a commercial partner, they could be providing funding, for example, actual funding, or it could be funding in kind. If they're providing up to 50% of the cost, between 25 and 50% of the cost, this actually will be treated as an NIHR strategic theme, and by that I mean you would potentially be given priority when it comes to making funding decisions if there is not enough funding to cover everybody who is fundable, if that makes sense. If you look at the NIHR Academy guidance notes for our fellowships, it will explain a little bit in more detail how that works. We also have an award called a Development and Skills Enhancement Award. This is a short-term award, and it's effectively a bit like a bridging award, and it's something which, as someone at a postdoc level could look to apply for at the end of their current NIHR fellowship or award. The idea being is it's there to give you some additional skills and experience in a particular field or area that would help get you in a good or strong position to apply for whatever else you're looking to do next. So they're usually around 12 months in duration. But a particular use of this DSE award is enabling you to get skills around entrepreneurship. So again, the guidance notes for this scheme will give you a bit more information as to what this means. But if entrepreneurship and gaining skills in working with an SME or with a commercial partner is something you're particularly interested in, but maybe feel you need a bit more training, skills, experience in, then I strongly encourage you to look at the DSE to think about how you might be able to use that particular award. Finally, if you're based within the NIHR infrastructure, and by that I mean, so for example, a biomedical research centre or an ARC, then what we have for you to potentially use is a short placement award for research collaboration, or SPARC. This is an award which basically gives you the opportunity to go and work with another part of the NIHR infrastructure to gain some new skills and experience in whatever area that you're particularly looking for. Next time we open this award, which will be in a few months' time, you will see there will be opportunities, or we're particularly encouraging you to think about how you might be able to go and work in another part of the NIHR that has got a strong or good skills and experience in terms of working with industry. So keep an eye out for that one. Just a few other things to mention when it comes to working with industry, and this is thinking about the types of additional support that you might be looking for as an NIHR Academy member, or someone who's wanting to build, I say, an industry collaboration into a future application. Some of the things we heard back at our conference, which we held in November of last year, with a theme on working with industry and entrepreneurship, were as follows. So I just wanted to give a bit of an update as to sort of the thinking we have around these. One of the things we heard strongly actually was around mentorship. So how might you be able to get access to industry mentors, people who actually are either based in industry or have significant experience of working with commercial partners. That's something we're still thinking through at the moment in terms of how we might be able to provide more opportunities through our various mentorship schemes. So keep an eye out for more developments there. Another thing we heard quite strongly at the conference was how you might even be able to identify opportunities for working with industry or commercial partners in the first place. So we're thinking about how we might best be able to facilitate applicants and interested companies getting in touch with each other ahead of making an application, or even if you're midway through an award and you're looking to form a commercial partnership, how might the NIHR Academy be able to best facilitate that? Things like training and webinars on specific topics was another area that came through quite strongly, IP being one of them, hence the reason we're having the webinar today, because that's something which quite a lot of people raised at the conference as something that they would like to know more about. We're looking at developing case studies so you can see actually how people have done this successfully already. So there should be more of those coming for you to get an understanding of how others have done it. I'm also keen to hear from you how else or what else you think will be beneficial or helpful here. If actually working with industry is something you want to do more of, but are struggling to know where to start, what is it that you would find helpful in this space, in addition to what I've talked about above? Please do get in touch with us, and we'll be happy to discuss it further with you. So that brings us to the end of the formal part of the webinar. For the time we have left now, we're just going to see if we've had any questions, and hopefully we'll get through as many of those as we can. So we've only had the one so far. So please, if you have any more questions, then please do send them in before the end of this session. So the first one we've had is a network of contracts. What do TTO and SME stand for?
So sorry, that's jargon and free acronyms. So TTO is a technology transfer office, although in your organisation that could be a contracts office too. So really go and find the appropriate support that is in your organisation. SME is it's a small and medium-sized enterprise, so basically a small company. We do support in some programs funding SMEs directly, and we are very supportive of funding SMEs. But again, you just have to be clear about what they'll contribute, and we'll make sure they've got the appropriate skills and expertise and financial stability to be a good partner for research that we fund.
Brilliant. A quick answer to one question that we've had is, are we going to get slides? Yes, so we are recording this webinar, so that will be available afterwards. So yeah, feel free to send it to whoever else you may think is interested if they've not been able to attend today. So another question we've had is, sometimes the setting up of contracts can take much longer than the period of funded research. What can we do in such scenarios?
So what we do under the NIHR contract is we will be very clear about timelines, and we'll put milestones into our contract. So we won't allow you to have NIHR funding if you don't have appropriate contracts in place. So for example, if you say in your application you're going to have a collaboration with a industrial partner, we'll either ask you that collaboration agreement before we start funding, or we'll put that as a deliverable early in the research period. So we might say after 3 months you have to give us a draft agreement for us to review. That means that we can be sure then that the funding is being used appropriately. If we allowed you to go through the whole research period without a collaboration agreement or a supply agreement in place, from our perspective, that's a big risk. Therefore, we're not really willing to let you do that, and we'll manage it appropriately via the contractual deliverables.
Yeah, brilliant, thank you. So thank you. We've had a few more questions come in now. Why doesn't the NIHR have a recommended template for collaborations under its various programs?
So that's because we fund a very diverse range of programs, and also we fund a very diverse range of organisations who each have different needs. So when we look at funding different organisations, we do make sure that they have the appropriate expertise, or we rely on the experts in those organisations to negotiate the appropriate collaboration agreement. So we don't have a standard template, because that wouldn't be appropriate for every type of collaboration. So we do, as we are funding organisations under contract to perform research, it's their responsibility to deliver the appropriate collaboration agreement.
Thank you. Next question is, if a commercial partner has approached me via the CRN, does this mean the NIHR or CRN can advise on setting up a contract?
Similar to the answer Lee just gave, that you know, we welcome that interaction, and it's good to know. But if we go on to fund the research, it's the contracting organisation who must then put in place an appropriate collaboration agreement. I think that's,
yeah.
Hopefully that answers it.
We can advise on. Excuse me, isn't it? Mm-hmm. The next question on background IP. So how far do you need to go for your background IP?
Really, it depends on the stage your research is at. We don't want you to do excessive amounts of work to demonstrate that the background IP is entirely risk-free. We know that it will never be risk-free. It's enough information to convince the funding board that there's an appropriate level of due diligence has been done. So it will depend on the type of research you're doing. If you're working with a previously published questionnaire, we'd want to know that you have access to a license to use that questionnaire. If you're using multiple products owned by different companies and there will be different licenses or supply agreements in place, that's a riskier aspect from our perspective, and we'd want to know there's more detail in place. Again, because we don't want to commit funding if there's a clear issue that will prevent research being completed successfully.
Thank you. The next one relates to patient and public involvement. So it says, if PPIE is part of the research, shouldn't PPI be part of the IP decision-making process, in particular around the public funding?
So clearly, yes, PPIE is a critical part of any NIHR funding application. In terms of its relationship to IP, both IP and PPIE, apologies for the acronyms again, both are important aspects of the overall application. So you should include both aspects in your application and make sure that they are appropriately described and controlled, because you need to have the holistic view of research and not purely focus on one aspect or the other. So the PPI aspect and the involvement of public members in designing research, identifying themes, reviewing applications, being on research funding boards and groups is all critically important to make sure that the overall NIHR funding process delivers what's in the public interest.
Yeah, brilliant. We're due to finish at 1. There's a couple of questions left, so hopefully we can get through them quickly. Well, people don't mind staying on a couple of seconds longer. The next one relates to someone who's received received funding but not through NIHR and are working with an industry partner. But as far as they're aware, there is no collaborative contract in place. The aim is to set up a social enterprise which will be self-sustaining, so that it has a bigger impact on society. How does this work? So is any advice on that particular scenario?
Well, social enterprises are companies, although they have certain legal statuses and certain foci. The aim is really to still be a company that makes a profit and is sustainable. So my advice would be going to talk to your contracts team or your technology transfer office as soon as possible, because what you're discussing with that industrial partner may affect your social enterprise. So as for any interaction, we suggest you go and talk to your support teams as soon as possible.
Yeah. And lastly, we will get through this last question. If you're when you're a large NIHR program, so I presume that means a large, maybe like a program grant, for example, that's based within an NHS trust, but many of your researchers are based or contracted to a university. If IP is generated in a project that is NIHR funded, who actually owns the IP?
So that will depend on the particular project and the ownership of background IP, the best way to manage the foreground IP to deliver patient benefit. So ultimately, although our starting position is that the foreground IP will be owned by whoever we contract with directly, if there is a better proposal, please put that in your application and we'll consider that as part of the funding review process.
Brilliant. Okay, so we've finished slightly past 1 o'clock, so apologies for that, but we've got through 8 questions, which is great. So I hope that's been helpful to everyone who's been listening. As I said, this webinar is recorded and will be available for you to listen to again at the end. And it's going to be on the NIHR YouTube channel, so please keep an eye out for that. So thank you very much, and that concludes the webinar.